Good evening, Justice McDonald.
Good evening.
Good to see you here today, and thank you for reaching out and giving both of us the opportunity to get to know a little of each other last Friday. I appreciate that reach that you did the other day. Thank you very much. Judicial activism seems to be the buzzword here today, and given obviously our system of three branches and every branch knowing what they need to do, what is your opinion about, is there any place at all, in your opinion, for judicial activism?
So I answered this before, and I'm happy to answer it again. The term judicial activism is not one that lawyers use. It is certainly one that is in our popular culture, and as I explained earlier, sometimes judicial activism is bless you, is in the eye of the beholder, and I have heard people on the right claim that a very conservative opinion might be characterized as conservative judicial activism, and I've heard people on, did I get that right? I think I inverted it. And I've heard it exactly the opposite, where very conservative people think a court opinion was a judicial activism because it was considered to be very liberal. I think in a broad sense, the popular notion of it, at least as I understand it, is when a judge takes their personal opinion about what the outcome of a case should be, and disregards the law in an effort to achieve that outcome. And I don't think that's a proper role for a judge to do.
And the reason I bring that up, obviously we've had since 10 a.m. this morning extensive discussions on several subject matters. And I would like to refer to something on the medical background. We haven't touched upon that this evening so far. And in our conversation, if you remember, I talked about a case where, when a HIPAA violation occurs, as it does right now by federal law, the federal law does not allow a HIPAA violation to be brought into a lawsuit. And I believe, and I want you to, educate me on this as to, in the case for Emily Byrne, and I'm not sure if you want to distribute that, so that, thank you. I'll just wait. During your tenure on the bench, the Supreme Court created a new civil cause of action, especially this being an example. And my concern is that this is despite the fact that HIPAA, the federal law, provides there's no private cause of action allowed for a violation of a HIPAA regulation. So I want to know that if the private cause of action is allowed, that has to come from the legislative branch and not from the judicial branch, because only when that is allowed could we proceed further. And it is my understanding that here this came from the judicial branch and went the other way around. So I would like you to comment on that.
Sure. That's so HIPAA doesn't have a private right of action under federal law. The case that created that right in this context was a common law right, not a statutory right. So the legislature can create statutory causes of action. The best one, perhaps off the top of my head, would be a CUTPA violation, right? So if there's a violation of the Connecticut Unfair Trade Practices Act, that is something that the legislature has created. Our law is replete with common law causes of action that are recognized by the courts, not by the legislature. The most fundamental one, probably about 90% of our cases in civil court is negligence, right? So there is that is a common law cause of action. If somebody runs a stop sign and hits your car and you're injured, that's a negligence claim that is a result of case law that says that if you are injured and somebody had a duty to not injure you and they breached that duty and they caused you an injury, you have a right to sue them in court. You will not find that anywhere in the blue books that we all know so well as the statutes of the state of Connecticut. That's a common law cause of action. There are a lot of others. There's the intentional infliction of emotional distress claim is a common law cause of action. Bystander emotional distress claims are common laws, meaning they're created by the court system, not by the legislature. And this cause of action, to be clear for the members of the committee who haven't read the case yet, my recollection of the allegation was that there was a woman who had a child with a gentleman. They were not married. There was a dispute in family court about that relationship. The father of the child subpoenaed medical records from the woman's gynecologist, I believe it was, and subpoenaed those records to be brought to court on a particular day. Instead of obeying that subpoena, the medical provider mailed the records to the clerk's office, and they were included in the court file, and they were not sealed in any way. The father was able to access those records. They contained extraordinarily personal information about the woman's medical history, and it was used for that information was used for very it was alleged that it was being used for very unsavory purposes. So the cause of action that we recognized was the disclosure, the unauthorized disclosure of the records to the court, or filing them with the court without notification to the patient. It wasn't a HIPAA, it may have been, it wasn't brought under HIPAA, but HIPAA was essentially used as the duty aspect of it to keep the medical records protected information and not to be disclosed to third parties without the patient's authorization.
Thank you for the clarification. But I get that. But my concern is that this is a HIPAA violation, regardless.
It may be that too,
right,
but this is a separate issue.
Right, but common law, case law, whatever we call that, is the basis by which you said that this could go forward. But when the federal law says it cannot go forward, so that's where, to me, I couldn't understand why we could go forward. So that was my line of questioning to you.
Fair. So HIPAA did not create a private cause of action. That's very different than preempting any other cause of action. It did not say there can be no that states were without authorization to have that as a common law cause of action. What HIPAA said is the information is private, but it is not a basis for a independent suit in and of that self, and that the remedies for HIPAA violations, as a doctor you probably would know better than I think they were administrative penalties through the Secretary of HHS, right. I think.
Yep.
And so that's a separate question about whether or not there can be a common law cause of action under state law.
So your take on this is HIPAA violation on the one hand, federal law on the one hand, but that would still allow the common law to go into effect in this particular case, which you were when you were on the bench.
Correct.
Thank you. Yeah. Just want to, going to your questionnaire, I'm going to question number 21. And then there was a complaint that was filed against you at the Judicial Review Council.
The reappointment one. Okay.
Right.
Yes.
And I would like your comment on that.
Sure.
I'm sure you know the complaint, and we all know, we've all read what, so my question to you is that how come there was no comment by the Supreme Court when it was denied?
So to be clear, this was a petition asking the court for permission to appeal from, I believe it was from the appellate court to the Supreme Court.
Correct.
We get hundreds and hundreds of those every year. And the members of the court review the petitions, and we vote on those petitions. And if they are denied, a order goes out that simply says the motion has been presented to the court, it's been considered by the court, and the petition is denied. And if it is granted, we would say it's been granted, and we are posing particular questions that we're going to allow to be considered by the court. It is, for as far as I know, hundreds of years been the case when petitions are denied, they are denied without explanation. And that's what happened in this instance. And this litigant was unhappy with that, and filed a grievance against me and every single member of the Supreme Court, which were dismissed.
Thank you. Thank you, Justice. Thank you, Mr. Chair.